Can you start your video and unmute yourself, please? Calling the case number of SP4519123. This is the state of Michigan versus Mina Jenna Conley. Your appearance, please. That means tell me your name, ma'am.
Manaya Janae Conley.
Okay, and this is the date and time set for an informal hearing. It was set for 9:31. It's now 9:49. The officer has failed to appear. Therefore, this matter will be dismissed without prejudice. Any objection?
No.
Okay, but before that, ma'am, it's just not always going to be that easy, because I would like to note two things. You're driving at a disgusting rate in a construction zone. Mm-hmm. You are putting your life and that of construction workers in danger, driving your car in such a manner. Okay? When I read this remark that says you are going 81 in a construction zone, that sends me. Okay? There is no reason in life, and you are not that important, for you to be driving so recklessly and selfishly on the road. And then I look at the ticket, and the trooper gave you a deal and wrote you a ticket for 5 over, which was a gift, right?
Right.
Because 81 in a construction zone, certainly if I do the math, is not 5 miles over the speed limit. And instead of taking responsibility for that and taking the loss and taking the break from the officer, you requested an informal hearing on it. And the break for you today is the trooper did not appear, so the ticket will be dismissed. But all that shows me, the court, is the type of person and driver you are. That you would drive in a construction zone where there are workers. Don't roll your eyes at me. Don't roll your eyes at me. And get a break at the road from the trooper. And instead of being gracious and responsible, you pushed for even more consideration. And you get that break today on a technicality because the trooper didn't appear. But you better think long and hard about yourself. If you roll your eyes again, I'm going to set this for another hearing.
I'm looking up. I'm looking in the background, never roll.
Okay, well, I would like you to look at me. There's no reason to be looking up.
Okay.
Show some respect and stop being such a selfish driver. And if you can't handle the responsibility of driving and the workers on the road, do everyone a favor and hang up the keys. Those men and women working out there are risking their lives. And the fact that you got such a break on the road and pushed it for a hearing today shows me that you think there are no consequences to your actions, and you should just be excused for your selfish behavior. Learn that you exist with other people in this community, and you are not important. You are not important enough to be driving and disregarding the other people and workers on the road. It is not about you. Slow down, be aware, and if you cannot be responsible enough, then don't drive, because it's a privilege. Are we clear?
Yes.
Okay, you may leave this.
Today's courtroom lineup is a masterclass in how quickly things spiral when people confuse luck with immunity. You're about to see 3 very different defendants, but they all share one dangerous trait. None of them seem to understand how close they are to real consequences until it's already too late. We start with a driver who narrowly escapes a serious traffic charge, not because she was innocent, but because the officer didn't show. Instead of gratitude, What follows is a blistering judicial reality check that makes it clear just how thin that line between freedom and accountability really is. Then we move into a bond violation case that goes from bad to catastrophic in minutes. A defendant walks into court already on shaky ground, gets a chance at leniency, and then completely self-destructs in real time. You'll watch the judge reassess the danger on the spot, turning a manageable bond into a crushing financial and legal setback, all because the defendant couldn't control himself.
Welcome back. So we're going to begin in case number 25-4703FY. Mr. Ullum is appearing for arraignment in the underlying charges. He had one failure to appear, but we had renoticed that, so he's not facing any issues with regard to a failure to appear for the arraignment in this case, just the bond violation issues.
Okay.
And arraignment in the underlying charges. So Ms. Ferrara-Wilbur, did you have opportunity to review the allegations on the felony complaint, nature of the offense, possible maximum penalties, as well as the issues with regard to the bond violations with Mr. Ullum?
Yes, thank you, Magistrate. We did have the opportunity to review the complaint and the alleged bond violations, as well as Mr. Ullum's rights in this matter. In regards to the underlying charges, Mr. Ullum waives a formal reading, pleads not guilty, and requests court-appointed counsel. In regards to the bond violation, he also waives a formal reading, pleads not guilty, and requests that it's set for a hearing with counsel.
So I will appoint an attorney for you. I'm going to remind you that you have the right to remain silent. Anything that you say orally or in writing can be used against you. You have the right to have an attorney present during any questioning, and if you could not afford an attorney, the court would appoint one at public expense. You have the right to have the attorney present during all subsequent court proceedings. Ms. Ferrara-Wilbur, is there information you'd like me to know regarding bond?
Yes, thank you, Magistrate. In this matter, we would request that the bond is reinstated. On May 28th, it was set at $25,000, 10%. As Mr. Ullum stated, he does part-time handyman work. He's currently homeless and has no access to funds for a bond, but he has taken steps to obtain a mailing address and has access to a phone to maintain contact with the court and counsel in this matter. Thank you.
Well, at one point, he had posted the bond through bonding agency. So he had been out, and thus the reason for the allegations on the bond violation. And with regard to that, Mr. Ullum, I am going to remand you to jail until the time of that hearing. So the bond that you did have is gone. You are no longer on bond. You'll be remanded again until the time of the hearing. We'll get that scheduled as quickly as possible. You should hear from your court-appointed attorney by the end of next week, and we'll make sure that the hearing is expedited.
This is one of those moments where people misunderstand what just happened. Yes, the case is dismissed, but not because the defendant was right. It's dismissed on a technicality because the officer didn't appear. And the judge makes it very clear that this is not a win. This is luck. What's important here is that the judge immediately reframes the situation. She looks past the dismissal and straight at the behavior. 81 miles per hour in a construction zone. That's not a minor mistake. That's reckless endangerment. And the court isn't obligated to pretend otherwise just because the ticket goes away.
We'll move on to case number 25-4779SM. And Ms. Ferrara-Wilbur, you had opportunity to review the allegations in this complaint, nature of the offense, and possible maximum penalties with Mr. Ullum as well.
Yes, that's correct. We did have the opportunity to review the complaint as well as his rights in this matter. At this time, Mr. Ullum waives a formal reading, pleads not guilty, and requests court-appointed counsel.
Based on the information that you've provided, I will appoint an attorney for you in this case as well. The next step in the process is a pre-trial conference. In this case, the pretrial conference would be scheduled for July 15th. It would be at 9:30 a.m. And again, Ms. Ferrara-Wilbur, information regarding bond.
Thank you, Magistrate. Based on the remand in the other matter, we would request a low cash bond in this matter.
So your bond in this case is going to be a $10,000, 10% bond. Conditions on this bond are that you may not use nor possess any alcohol, any illegal substance, any controlled substance, including marijuana, any mind or mood altering substances, or any non-prescribed medication. You'll provide a list of your current prescriptions to the district court clerk. You will submit to discretionary PBTs and discretionary urine screens whenever requested by a police officer or any court personnel, so you may not refuse. You would have an immediate urine screen and twice, we'll say 8 times per month, urine screens hereafter. You'll have no contact in any manner whatsoever with Darcy. Means no phone calls, no messages through other people, no mail. You may not text message nor through any social network have any contact with her. You will stay 500 yards or more away from her. You may not be at any address that she is or may be. Specifically, you may not return to 811 Linwood Lane. You may not use nor possess any.
No, Mr. Ulam. No, Mr. Ulam. No,
what address?
Mr.
What
Ulam.
address what address? I'm just confused. I just wanted to repeat I want to understand what the address was. What was the address?
The allegations in this complaint allege that it was at the residence at 811 Linwood Lane, but you can't be at any address that Darcy Robinson is or may be. You may not be within 500 yards of her workplace.
I understand. No, I get it. I get it. I just want to clarify that I can't go to my home. I can't go to my house. I get it.
Mr. Ulam.
I'm homeless and I can't go to my house. Thank you. That's good. Thank you. Just making it clear that I'm not allowed to go to my home. Thank you very much.
You may not use or possess any weapons of any sort. You'll have no threatening, intimidating.
I know what the last ones were. Thanks a lot. What are you talking about? Oh, man. You took away from my phone. Hey, tell Darcy Robinson not to bomb me out again, too. She bombed me out last time. Tell her not to bomb me out. Hey, come on.
So the words that I'm speaking about the no contact are in effect immediately, Mr. Ulam, and it's going to be a $25,000, 10%.
This is where the tone shifts from stern to zero tolerance. The eye roll may seem small, but in court, it's a direct challenge to authority. And this judge shuts it down immediately. What you're seeing here is not about speeding anymore. It's about attitude. The judge recognizes something dangerous: entitlement. The idea that getting a break once means you deserve more breaks forever. And she calls it out directly. This isn't about embarrassment. It's about public safety and personal responsibility.
All right, parties. I'm gonna figure out, and then we'll determine whether or not how we're gonna proceed. How we're gonna continue on. So I need both of you to unmute for me.
Yes, sir.
All right. Both of you raise your right hand for me. You swear or affirm to tell the truth under penalty and perjury of the law?
I do.
I do.
So let me first get a little bit of basic information. So Trust Property Services, do you guys have is this a commercial or residential?
This is a residential property.
All right, great. And when was the lease entered into?
March 25th, 2019.
Okay, when was it last renewed?
It was renewed on, it was signed on March the 9th, 2022.
Okay, and has it just been renewing every month since then?
Yes,
I mean,
sir.
every year on the other.
Yeah, every,
okay. All right. So renewed again on March 2025, but I understand that there's allegations of default before then. So how much is monthly rent?
$1,750.
Okay. Is there a late fee? If so, how much?
There is a late fee, Your Honor. The lost discount is $100, and then there is a $10 per day additional rent, but I understand you have it capped at 10%.
Yeah, so we can do it at $175, which would be the most. When's the last time the tenant paid rent from any source?
That was on the ledger there. It was February 25th, 2022.
It's the last time you paid any rent?
Excuse me. No, sorry. That was when he started paying rent again. So previously he got behind significantly and the county stepped in and
Objection,
paid
Your Honor.
Okay, well, he can tell me what he wants to say. Overrule. Continue.
Okay.
Okay.
And March 25th, 2023 was the last time rent was paid. So we began accruing rent at April 25th, 2023.
Okay, well, your complaint doesn't ask for all of that. It says that it is from December 25th, 2024 through March 2025. So explain that to me.
I did not file it myself. My assistant has been in the hospital 4 times and some weeks at a time. So I'm not sure what was filed.
Well, that's a concern because you're pursuing this. I got that this was filed back on, this was filed April 8th or April 18th. So this is well after that. Well, for an opportunity for you guys to make any additional determinations. I just want to make sure we have some clear numbers because the numbers that you're asking for in the complaint that was past due in April of $10,000, that was for rent through March.
Could you state, I'm sorry, sir, could you state that amount again? The thing went in and out.
Past due rent of $7,000, and that's for the months of December 25th through March 25th, 2025.
Yes, sir.
Okay, so I just want to make sure that you're aware of that. I understand that you're the agent, but so he hasn't paid rent, at least according to the complaint, since then, and you guys have not received any monies since December or since November at all, or at least in some.
That's correct, Your Honor. Not that I'm aware of.
Okay. All right. Well, just hold tight. Let me speak to Mr. Stevenson. So, Mr.
Yes, sir.
Stevenson,
What's going on?
when did the initial lease get signed? You recall?
Yes, sir. It was signed probably in 2019 or 2020.
Okay. When's the last time you signed a lease?
The last lease I signed was probably in 2022. I would like to say that I'm perfectly fine with answering all your questions, Judge. Nothing. I've filed a lot of evidence in this case showing that they have not done their due diligence whatsoever in this proceeding, which you've already recognized to a degree with their misnumbering of their own numbers. But I don't. I'm challenging the jurisdiction of the court. I don't believe this belongs in this court. I reserve all my rights, and I do not consent to administrative process and without equity, according to Article 3.
And just like that, we move from reckless driving to something far more serious, bond violations. This is where the stakes multiply fast. A bond is trust. It's the court saying, we believe you can follow the rules while this case is pending. And once that trust is broken, everything changes. This defendant is already walking into court on thin ice. And while the court initially shows restraint, that patience has limits. What makes this situation dangerous is how quickly circumstances shift. One moment, he's being addressed calmly. The next, he's being remanded.
With due process under law, because I have a lot of evidence showing that I did my due process and did not receive that from them. Basically, that $7,000. He's saying that they just submitted a ledger to you guys saying that $65,000 is owed. And saying
I haven't seen that ledger.
But
so
he just said at the mediation. I'm not assuming.
So just hold tight.
Yes, sir. I'm just saying I got a lot of stuff, and it's a real case.
And then we, if need be, I can get into all of that because right now,
yes, sir.
One, what you discussed in mediation, I'm not aware of, right?
Yes, sir.
So I all of that. That's why I like to ask my questions. And
yes,
then
sir. I just wanted to make sure I got on record that I do challenge that we should even be in this court.
And I would say, if that's the case, did you file a?
I will.
But you haven't. So you have not sought to have the case removed to federal court, have you?
Not the federal yet. I was trying to get it removed just to Superior.
Okay. And under what basis?
Under the basis of equity. This is a rent-to-own case. This is not a normal tenant-landlord situation.
I would pause you because I'm very familiar with that. And if it's a rent-to-own situation, those generally are still considered contracts. You may have a lease, otherwise. And so just before we get into that.
Okay.
Because I've been doing this a little while. So,
I'm with you. I'm with you.
all right. So tell me, is rent $1,750?
Your Honor, I'm not aware of what the rent is currently.
Well, you told me that you signed a contract back in 2022.
The contract that I signed, the rent was not. If you review,
oh, how much is it? How much is
the rent that I signed at the time the contract was $1,450.
Okay, $1,450.
It was $1,450.
Just getting information.
Yes, sir.
Okay.
I'm with you.
Did you submit your last contract online? Did you submit it as part of your evidence?
The contract, no, neither one of us submitted the last contract signed. I can't produce it, but I did not submit the last.
So hold on. Let me do my job. Okay.
My bad.
So you're saying that the last rent is $1,450. Was there a late fee associated with that $1,450?
I believe so.
Okay. And let's just say for giggles, because we only gonna give him 10%, there was $145. Right. So tell me this. When is the last time you paid rent? Or anybody on your behalf?
I believe the last time that I paid rent would have been in the year of 2023, December of 2023.
This is the moment most defendants don't fully grasp until it's too late. That bond money, it's gone. The second a bond violation is confirmed, especially alongside a new felony, the court doesn't hesitate. The $25,000 bond at 10% evaporates instantly. Notice how unemotional the decision is. This isn't punishment, it's procedure. Bond exists to ensure compliance. Once compliance fails, the privilege disappears. And now, instead of walking out, the defendant is being remanded back into custody with no bond at all until a hearing can be scheduled.
Okay. And so, just to kind of get some clarity, December of 2023, that means all of 2024, and now we're moving into 4 full months of 25. And then if I were to give a writ, right, you would have 7 days. I understand you saying you ain't got no jurisdiction, all that stuff. I just want to understand what I'm working with. So it essentially would have been 16 months plus 13 days. Now, that's not what they're asking for.
Correct.
But you're saying you haven't paid rent at least for about 16 months.
Correct.
Okay. And is there any basis of why you've not paid rent for 16 months?
Yes, sir. They have some funny accounting. And so I submitted in accordance with UCC and all other statutes and legal statutes. I submitted a request for accounting, a full request for accounting, which I have a right to do. I submitted it under certified mail to the registered agent's address per the law. The registered agent received the first letter. I have all received, everything's in front of you in the submitted stuff. I submitted a document requesting a formal request, asking and saying that I would pay whatever was needed as long as they produced actual documents, especially because they're filed under a trust. So they're supposed to complete certain things as a part of their business model of how he's even running his